Please be seated. This is case number 2012-01, Brian Lochte versus Michael Franklin. Ready for argument?
Thank you, Mr. Chief Justice, and may it please the Court. My name is Patrick Bottini, and along with my co-counsel, Mary Laird, I represent the petitioner, Officer Brian Lochte. Officer Lochte is being sued under 42 U.S.C. Section 1983 for the alleged deprivation of the respondent's First and Fourth Amendment rights. I will be arguing the First Amendment issue, and my co-counsel will be arguing the Fourth Amendment issue. We'd like to reserve 2 minutes of our time for rebuttal. On behalf of Officer Lochte, I urge this Court to reinstate the District Court's grant of summary judgment in favor of qualified immunity. Officer Lochte is entitled to qualified immunity because the rights asserted by the respondent were not clearly established at the time of his arrest. Turning to the First Amendment context, the First Amendment rights asserted by the respondent were not clearly established for 3 reasons. First,
you don't want us to reach the merits of the substantive claim?
No, Your Honor. As this Court held in Pearson v. Callahan, the Court need not reach the legal merits if the right asserted was not clearly established. And the reasoning behind this was that qualified immunity is a freedom from suit. It's not a defense to liability. So when a right is not clearly established, an officer need not go through the merits of the case, because otherwise that would jeopardize the concerns of qualified immunity, which is to protect officers from having to delve into the intrusive process of discovery and litigation when, in fact, they were acting reasonably and the right was not clearly
But when you
asserted.
say you're going to address the First Amendment issue, you're not talking about the merits of the First Amendment, but only whether or not the right was clearly established.
Yes, Your Honor.
So you don't want us to decide the First Amendment issue.
The Court need not decide the First Amendment issue, and it certainly need not decide the First Amendment issue for the petitioner to succeed on his qualified immunity defense. So when I say I'll be addressing the First Amendment right, it's the First Amendment right that is asserted by the respondent, and the question of whether or not that is clearly established under the existing authority. The First Amendment does protect some general right to record matters of public concern. This Court has held as such in cases like Mills v. Alabama and Hushins v. KQED. But that right is not absolute. In fact, the periphery of the right to record is riddled with exceptions and doctrines that protect public officials and police officers in their reasonable discretion in the enforcement of this nation's laws. Chief among those doctrines is the doctrine of qualified immunity. Qualified immunity is, in essence...
Well, but that doctrine doesn't protect an officer with regard to the substantive issues. It's just protection in case an officer exercises his or her discretion within an area where the law is unsettled. But it doesn't go to the substantive merits of whether or not there's been a violation.
That's correct, Your Honor. And Officer Lochte need not prove one way or another that the right itself actually exists. It is only whether or not there was sufficient notice under the law that this right was clearly established. And so delving into the substantive issue is not necessary under this Court's jurisprudence in Saucier v. Katz, which was changed by Pearson v. Callahan. Qualified immunity is an agreement between public officials and police officers on one hand, and the courts on another hand, that says when an officer exercises their discretion reasonably, they are free from suit when there is unsettled law that they could not reasonably have had notice of. That was the case here today. In order for a defendant to prove that a right was not clearly established, he must do so first by addressing the authority in the case. This is essentially an objective reasonable test laid out by this Court in Wilson v. Lane and Anderson v. Creighton. The question is whether or not the legal authority in place at the time provided sufficient notice such that all reasonable officers would know about the specifically defined right at issue.
Well, let me ask you this. Your client takes the position that this arrest was lawful under the New London wiretapping statute, but I couldn't find anything in the record that revealed for us what the communication was that was recorded. What was the communication? What was the big deal here?
First, Your Honor, I should note that Officer Lochte need not prove that it actually was a legal enforcement of this law, just that a reasonable officer could believe that his actions were reasonable in this case.
Well, what was the communication that could give us any basis to say that what he did here was reasonable?
Your Honor, as noted on the record on page 5, Officer Phelps, the undercover officer in this case, was speaking with another police officer, and that was the subject of the recording, as was recognized by the respondent himself, again, on the record at page 5.
Substantive content of the communication, but only the existence of the communication that you say was within the scope of the local statute?
Your Honor, it's the fact that a conversation was being recorded at all. Wiretapping statutes and eavesdropping statutes have existed in this country since the common law, and these protect the conversational privacy of all citizens, not just police officers.
But if you can't tell us what the conversation was, how could he have been reasonable in his belief that the statute applied?
He could have been reasonable because there...
Warning.
Yes, Your Honor, but even that communication is protected by wiretapping laws. We have a right to be free from intrusion into our private conversations. And
Even ones that are being made in public?
Yes, Your Honor. In many cases...
You're telling me that if I decide to speak with someone here right outside of this building and someone happens to pass by, that my conversation is protected?
It's protected from someone who is intentionally intercepting it, which is the conduct that was specifically made illegal in this case.
Someone intercepts it by hearing it. Is that illegal?
Excuse me. Sorry, sir.
If someone intercepts it just by hearing it, is that illegal?
If they do so with the intent to intercept it, to record it under this law.
So if I just pass by, listen to a conversation being held by two others, and I happen to have a photographic memory of some kind, go back to my dorm, write every single word down, and then put it on a blog, there's been no violation of the wiretapping ordinance, right?
Yes, Your Honor. It is
that
conceivable.
world makes no sense.
Well, Your Honor, it's important to note that at the time of these facts, there were 10 states, almost a third of this nation's population, that lived under eavesdropping laws that made that exact act illegal unless the listener had consent of all parties. So again, the court need not decide prospectively whether that is a good or a bad law, or even whether that law violates the First Amendment. The court need only decide whether an officer could reasonably have believed that the conduct at issue here fell within the purview of that law. And again, these laws have existed, and they existed at the time, one of which has been struck down since the actions here in the Seventh Circuit. But if you are not...
The shoe had been on the other foot, and the officer was investigating criminal activity, and he had a camera, and he took pictures of somebody who was arguably committing a crime, and that defendant in a criminal case moved to suppress on grounds of Fourth Amendment. The officer would argue, well, heck, it's plain view. Why isn't this plain view?
I'd like to address that in two parts, Your Honor. The first is that this law only outlaws the recording of verbal conversations. So this protects conversational privacy, not that conduct at issue here.
So if he had... No, please.
Well, it goes back to my original question then. If you can't tell us what the conversation was, it strikes me that you're taking the position that it was the existence of the conversation itself.
It was the fact that two citizens, be they police officers or not, were exercising their right to speak privately to one another and to be free from intrusions. And again, Your Honor, regardless of the conversation, this is a right that has been protected by eavesdropping laws since the beginning of this country. And if this court wishes to strike down those laws, it may do so prospectively, but that has no bearing on whether or not Officer Lochte had sufficient knowledge at the time that he could enforce this law, given that the conduct fell within that.
What precedent of any court provides that you can be criminally prosecuted for intercepting conversations made in a public place?
Well, Your Honor, there's quite a bit of case law here in favor of Officer Lochte's argument that the rights here were not clearly established, and they occur in similar instances where a police officer is involved and there is a public incident. So looking specifically at the cases on point here, in the Third Circuit, Kelly versus Borough of Carlisle, someone was recording during a traffic stop, the passenger of the car that had been stopped. And the court there found that there was not a clearly established right to record that, even though it was plainly in the public.
Qualified immunity decision. I'm asking you on the merits. What precedent is there for the proposition that someone can be criminally prosecuted for recording a conversation made in public?
Well, again, Your Honor, I would first state that Officer Lochte need only prove the qualified immunity prong to succeed.
I know, but part of that clearly established paradigm has to deal with the opposite side of the equation, and that is, what law is there that suggests that what he was doing was okay constitutionally? And so my question is, what precedent out there gave him any idea that what he was able to do was going to be okay?
Well, in specific cases where it was in the public, I think a good place to look here is a case relied on by the respondent, which is Glick versus Cuniff, and specifically the case relied on by that court, which was the First Circuit, Commonwealth versus Hyde. And this is fairly common of wiretapping statutes of this nature. That case defined whether or not a right was secret or whether or not it could fall within the purview of a statute like this, based not on an expectation of privacy that made distinctions between public and private, but between whether or not the subject had actual knowledge. And in that case, the court said it could be in public that someone didn't have actual knowledge.
Why does knowledge matter constitutionally?
Well, again, Your Honor, constitutionally, we're interpreting a state law, and the constitutional right at issue here is the right to break that law. Sorry, can you repeat the question?
Sure. In constitutional terms, for purposes of the First Amendment, and I know you're arguing qualified immunity, but I'm trying as best as I can to draw you away from that. So in constitutional terms, for the substantive First Amendment claim, why does the speaker's knowledge matter? Constitutionally, why should it matter? If I get on a soapbox this afternoon and speak to whoever wants to listen on the lawn, and someone who is 500 feet away with a really good recording device and video device records me without letting me know that he or she is doing it, why does my knowledge matter in terms of that person's constitutional rights if I'm speaking in public?
Because as this court has noted in Bartnicki versus Vopper, privacy in this sense, in whether or not the conversation that you're carrying on is being recorded by another person, is a compelling governmental interest. As Justice Stevens said in that case, the First Amendment protects not only the right to speak, but the right not to speak. And so states have, and they continue, to use actual knowledge as a determination of whether or not there was sufficient privacy being protected, or whether or not the recording itself was secret. And then going back, Your Honor, to the qualified immunity prong, Officer Lochte had no guidance that this was the type of activity that did not fall within the purview of a legitimate state law. There was no...
Didn't the Glick case that you just referred to, didn't it give him guidelines under these circumstances?
Respectfully, Your Honor, no, it didn't. That is a case in the secondary persuasive authority. It flies in the face of...
It's secondary persuasive?
Yes, Your Honor. It was in the First Circuit, and Officer Lochte works in the 14th Circuit. It was not direct authority. And that's a distinction that this court has drawn, because, again, this is a question of reasonable notice to police officers. Glick versus Cuniff was one case where they held that the right was clearly established. But within 2 years of the events in this case, there were courts in the Third Circuit, in the Fourth Circuit, in the Eastern District of Louisiana, and 6 months before the events in this case, in the Western District of Pennsylvania, that held this right does not exist. For Officer Lochte to focus on just the one court and find that their legal reasoning was the best would force him to parse the minutia of constitutional law, which is exactly what this court has held officers should not be forced to do.
But you're assuming that the concept of qualified immunity is something more than just a pure legal fiction designed to do something more than set up and calibrate policy values. We know that police officers aren't reading the advance sheets day after day to find out what the 7th or the 6th or the 11th or the First Circuit's decided. After all, if in your jurisdiction the circuit had decided a case exactly like this 24 hours before your client took the actions that he took, you wouldn't have a qualified immunity argument, right? Despite the fact that your client subjectively was not aware of the decision.
Your Honor, I see my time has expired, if I may answer the question.
Sure.
Ultimately, it comes down to objective legal reasonableness, and that is determined based on the notice that is given by courts. So in the scenario you presented, it may have been that if the court had ruled on this right, then Officer Lochte would have indeed been violating a First Amendment right. But that would not speak to whether his actions were reasonable under the qualified immunity analysis, which is a lower prong than, say, probable cause. It requires not that we determine if the officer's conduct was reasonable or should have been reasonable, but whether or not some reasonable officer could have agreed with Officer Lochte in this situation. And in the face of a complete silence, a deafening silence of direct authority and mixed and conflicted persuasive or secondary authority from other circuits and other district courts, Officer Lochte cannot be found to have been given notice. This court requires not just one case here or there. It requires that the legal authority put the right beyond debate, which is this court's words from Ashcroft versus Al-Kid, and that was not the case here. For the foregoing reasons, we ask that you please reinstate the district court's grant of summary judgment in favor of qualified immunity.
Thank you very much.
Good afternoon, Your Honors, Mr. Chief Justice, and may it please the Court. My name is Mary Laird, and together with my co-counsel, Mr. Bottini, I represent the petitioner, Officer Brian Lochte, and will be addressing his Fourth Amendment claims. The alleged unlawfulness of the search
In the context of qualified immunity?
Yes, Your Honor. The alleged unlawfulness of the search of the internal contents of the respondent's cell phone was not apparent in light of pre-existing law. And for this reason alone, Officer Lochte is entitled to qualified immunity from suit in his individual capacity. And this court should reverse the holding of the 14th Circuit Court of Appeals and grant summary judgment in Officer Lochte's favor. Officer Lochte presents his affirmative defense of qualified immunity before the court in three prongs. That first, because there was no consensus of controlling or persuasive authority, the specific right asserted was not clearly established. Secondly, that once arguable probable cause existed to arrest the respondent under New London's wiretapping statute, a reasonable officer could not have been on notice as to the unconstitutionality of a subsequent search of the contents of the respondent's cell phone. And that thirdly, even if the right was clearly established at the time, there was no constitutional violation, as the search was justified both incident to a lawful arrest and due to exigent circumstances.
I understand the clearly established prong, but why does the concept of arguable probable cause make any sense whatsoever?
And so, Your Honor, it's most accessible if I preface it with referring to my co-counsel's standard of objective legal reasonableness. And so if we require officers to have notice for when their conduct is going to violate constitutional rights, the right must be specific, and it must be specifically asserted. And arguable probable cause, or probable cause at all to arrest the respondent, is necessary in order to determine if there was a search incident to arrest. And if there was a search incident to arrest, whether Officer Lochte could have searched the respondent for his cell phone and then the internal contents of his cell phone. And so it's a chain of events, if you will. An arguable probable cause is the linchpin upon which the constitutionality of a subsequent search seems to rest.
So why should it be arguable and not probable cause? It's been established for centuries, I mean decades now, sorry, that someone has a right to not be arrested except upon probable cause. So why do we include the concept of arguable probable cause into the equation?
Yes, Your Honor, and if I might distinguish your question into two parts. And the first is that you're correct. Probable cause would be the standard for the merits of a constitutional violation. However, under the qualified immunity context, as Justice Scalia iterated in this court's opinion in Anderson versus Creighton, we require something less than probable cause. We require only that a reasonable officer could have thought that he had probable cause to arrest.
My question is, why does that make sense?
For the simple reason of the touchstone of this court's decision in Harlow versus Fitzgerald, which is objective legal reasonableness. We don't require that there actually be probable cause. We don't even require that all officers would have thought they were probable cause. In order to prevail on a claim of probable cause for a search incident to arrest, the respondent would need to show, as a hypothetical, a consensus among all hypothetical officers that they would have known that their conduct was about to violate a constitutional right, which is why we have the two prongs that inform the inquiry of objective legal reasonableness.
I don't understand how it is the case that any reasonable officer could read the New London wiretapping statute to cover taking pictures of somebody in public having a conversation. Doesn't a wiretapping statute apply to wiretapping? You know, the government intercepting electrical communications in order to discover or uncover criminal conduct. What's the wiretapping statute got to do with taking pictures in a public park?
And so, Your Honor, if I might just, as an initial matter, distinguish between taking pictures and the intercepting of oral communications, which is what the wiretapping statute criminalizes in this case.
Well, what were the oral communications? I asked your partner, and your partner wasn't able to identify any communications.
Sure, and so if I might build upon what my co-counsel, I believe, was getting towards, is that the substance of the communications has no bearing on whether or not there was a violation of the plain language of the statute. And
That sort of converts this country into a police state, doesn't it? Look, didn't the police in this case create the very exigent circumstance that you argue justifies the search? I mean, here's this peaceful group with no evidence, based on the record that I've read here, no evidence of prior violence. They're peacefully demonstrating about the unequal distribution of wealth in the United States, and our government infiltrates it with an undercover police officer. Does that sound like the United States or some repressive, despotic regime? And then after they get caught doing it, and a public-spirited citizen takes pictures of it, they arrest him and steal his camera. I mean, does that sound like the United States? And the reason that I ask the question is not for any rhetorical basis, but if I took a poll, I wouldn't think most policemen would think that that would be reasonably objective conduct.
And no, Your Honor, if I may address your question in several parts, then I hope I can do so thoroughly. The first is that while there is no evidence on the record that this protest had turned violent, on the record at page 5, Officer Lochte does note that similar protests with similar organization and similar motives had already turned violent. As a secondary matter, in order to prevail, Officer Lochte does not need to show exigent circumstances, but rather there is a presumption, a per se presumption of reasonableness from this court in United States v. Robinson that searches incident to arrest extend to...
But the arrest is bad, isn't it? I mean, what was the probable cause for this arrest?
Your Honor, the probable cause and the arguable probable cause, which is the standard for Officer Lochte to show, is that there was a violation of the plain language of the statute, which turns...
But suppose we conclude that the plain language of the statute does not contemplate what happened here. Aren't you sunk?
And Your Honor, respectfully, no. This court is free to prospectively decide that that the language did not apply.
No, we would conclude that in the history of the United States, it is highly unlikely that any reasonable police officer would have done this. Then aren't you dead in the water?
Respectfully, Your Honor, no, due to the secondary argument of exigent circumstances, but I would emphasize that specific to the Fourth Amendment claims, there are two circuits that have held that a search and seizure pursuant to an arguable lawful arrest, even if the arrest is found not to be lawful after the fact, if an officer could have thought that he had probable cause under a similar statute, then he has a per se presumption of reasonableness from United States v. Robinson to search anything within the immediate area of the arrestee's person.
Would your client, do you think, have made the arrest if there was only a videotape and not an audio tape?
Your Honor, I'm not sure that the distinction is important under New London's wiretapping statute, which criminalizes both oral, or which criminalizes the oral, so whether there was no audio component of the video. Is that the crux of your question?
Well, you can't intercept it if you don't record it.
Right, and so if the respondent had not been, if his phone perhaps had lacked oral capability, we would still argue that Officer Lochte had probable cause to believe that a cell phone, a commonplace item, to which all of us, I believe, would be remiss if we didn't know had the capability to record both audio and oral components. I don't believe that my own personal cell phone has the ability to do one or another. And the courts have not provided any guidance sufficient to have Officer Lochte parse that detail of when a search would have been reasonable.
But if that's the situation, then maybe qualified immunity has been erected to the point where it's insurmountable in all cases involving alleged constitutional violations. Because what you and your co-counsel seem to be saying is, if the officer thought X, and even if X wasn't true and Y was true, but then he thought A and A wasn't true, but B was true, and then thought C, but D was true, maybe some officer out there in the country would have thought the same things that he did, even though he was fully mistaken on all three, even though the Constitution was blatantly violated, and he walks away.
And so, Your Honor, as a legal matter, your hypothetical is true much of the time.
And maybe we should rewrite qualified immunity law
And maybe we should, but
in this case.
As a retroactive matter, holding Officer Lochte liable for the standard at the time of arrest, when he was informed by two persuasive circuit court opinions that there was an affirmative presumption of legality in his favor.
He had read those?
Perhaps no, but as you remarked to my co-counsel, qualified immunity is a legal fiction.
Well, but then how can you say that he had these persuasive cases out there? It's all a fiction. He didn't read the others, right? He didn't go to a civil liberties class at Notre Dame Law School to figure out which ones made more sense and which ones were truer to the spirit of the Fourth Amendment at the time of the founding or anything else like that.
Yes, Your Honor, and even for my own civil liberties classes, I admit I had read none of these cases. But as a legal matter, when we impute legal knowledge to an officer to determine whether a reasonable officer would have been liable, as Justice Scalia emphasized in Anderson versus Creighton, his subjective knowledge or his subjective intent is irrelevant when we hold an officer liable in his personal capacity, which is to be distinguished from holding an individual liable for their official capacity, for actions that were not reasonable and for which the courts and legislatures have provided no guidance. If Officer Lochte could not have known that his conduct was unconstitutional due to a lack of controlling or persuasive guidance from courts or legislatures, he cannot be held liable in civil court.
Wouldn't he have known this just from his basic training at police academy when they instruct them about what is a lawful arrest and what is a lawful search? Why would he ever have to consult conflicting circuit court opinions to reach a conclusion that what he did here was objectively unreasonable?
And so, Your Honor, I don't believe that Officer Lochte would have consulted them, but the opinions provide perhaps guidance to policy statements from police departments that would have informed Officer Lochte of the constitutionality of his conduct.
There's no police department in the country that is distributing legal information at this level of minutia to their police officers. They're relying on good sense, good judgment, and qualified immunity gives them the edge when there's an arguable case. But in this case, when you read the facts, one just reacts in outrage at what happened here in an attempt to use the relatively expansive doctrine of qualified immunity to justify it.
And well, Your Honor, again, it all comes down to whether Officer Lochte would have had notice, perhaps as a legal fiction, for as a legal court, we are from the top down imposing liability on him for decisions that are made in his day-to-day exercise of his official duties. And there is perhaps a difference between holding someone individually liable based on the persuasive circuit precedent, which I admit is certainly a hard standard to overcome, and is certainly, we would be hard-pressed to find an officer who can, as this court emphasized in Percunier versus Navarrete, parse the minutiae of constitutional law.
Are we to be looking at this in such a broad sense as the questions have been posed? And isn't the qualified immunity to be analyzed under the specific facts that were involved and whether that specific fact circumstance, the law was clearly established?
Yes, Your Honor, that's precisely correct, and the specific facts must be tailored to the specific right, which, if I might have liberty to address, the specific right at issue in this case is precisely as it was addressed in the Fifth and the Seventh Circuit in United States versus Finley and United States versus Flores-Lopez, both within the past 5 years. And the right is the right to be free from the warrantless entry by police officers into the contents of one's cell phone or perhaps a similar technological device.
How about going even before that? Who were the actors here? And was it part of the movement, if you will? It appears that it was just two people involved. one was a police officer in uniform and one was an undercover police officer.
Yes, Your Honor. Officer Phelps, the undercover police officer, was having what we would contend is a private conversation with the on-duty police officer, and were observed by the respondent in the course of this communication. Mr. Franklin began videotaping, and the interception of the oral communications of the two individuals is when we would contend that there was arguable probable cause to arrest under New London's wiretapping statute. And so pursuant to the valid statute, which has not been contested, and the probable cause that existed to arrest, based on the circuit precedent that my co-counsel addressed from the 10 states that do define a violation of a wiretapping statute as merely the lack of consent. And Officer Lochte